हेलो दोस्तों, आप लोगों का स्वागत है हमारे चैनल टेक्लॉस पे। तो आज हम लोग बात करेंगे, डिस्कस द डॉक्ट्रिन ऑफ इम्पॉसिबिलिटीज टू परफॉर्म ऑफ ए कॉन्ट्रैक्ट विद द हेल्प ऑफ रिलेवेंट केस लॉ। सो हम लोग केस लॉ डिस्कस करेंगे। आई जस्ट गिव यू अ ब्रीफ लाइक व्हाट वी आर गोइंग टू डिस्कस। सो वी आर इनिशियली डिस्कस द इनिशियली इम्पॉसिबिलिटीज, सब्सिक्वेंट इम्पॉसिबिलिटीज एंड डॉक्ट्रिन ऑफ फ्रस्ट्रेशन हम लोग डिस्कस करेंगे। हम लोग डिस्कस करेंगे स्पेसिफिक ग्राउंड फॉर द फ्रस्ट्रेशन, effect of the frustration, and then we will conclude our question like the topic. So first of all, the introduction, I'll let you know like the entire topic of the frustration is elucidated from the doctrine of frustration, section 56 of effect of frustration, section 65 as the mention in the Indian Contract Act. Okay, so section 56 and section 65 is very important in this topic, the topic of impossibilities and the the doctrine of frustration. Okay, so basically, first of all, I am going to discuss the element of the doctrine of impossibilities and, like you can say, the doctrine of frustration. So unforeseen event, first of all, the basic element is the event must be unforeseen and beyond the control of the parties. If event is control of the parties, then it is not uh, the he is not comes under or fall under the doctrine of frustration. Okay, and objective impossibilities, the performance must be objectively impossible, not just difficult or economically burdensome. लाइक जो ऑब्जेक्टिव है वो इम्पॉसिबल होना चाहिए एंड नो फॉल्ट ऑफ द पार्टीज, एंड द इवेंट मस्ट नॉट बी कॉज्ड बाय द फॉल्ट और नेग्लिजेंस ऑफ आइदर पार्टीज। और जो कोज है, जो लाइक बिकॉज ऑफ दैट इवेंट इज नॉट हैपनिंग और हैपनिंग because of it's not under control of the parties and it's not the fault of the parties. No party can be liable for the occurring of that particular event or non-occurring of that particular event. So initial impossibilities को हम समझते हैं सेक्शन 56 के साथ में। सेक्शन 56 of the Indian Contract Act 1872 being by laying down a straightforward principle that in agreement to do an act impossible in itself is void. So इसमें कहा गया है सेक्शन 55 में कि ऐसा एग्रीमेंट जो कि अपने आप में ही होना इम्पॉसिबल है, वो एग्रीमेंट अपने आप ही void हो जाएगा। फॉर इंस्टेंस, इन एग्रीमेंट टू डिस्कवर treasure by magic because of it impossible to perform is void. So एक एग्जांपल हम लेते हैं, जैसे कि एक एग्रीमेंट कि हम लोग है ना कोई खजाना ढूंढ लेंगे जादू से, और ये जो एग्रीमेंट है ये अपने आप में ही void है क्योंकि ऐसा करना इम्पॉसिबल है। ओके, सो ये एग्रीमेंट void हो जाएगा। इन एग्रीमेंट टू डू एन एक्ट दैट इज इम्पॉसिबल फ्रॉम एवरी वेरी बिगनिंग, वट एवर द पार्टीज वर अवेयर ऑफ सच इम्पॉसिबिलिटीज और नॉट, द एग्रीमेंट विल बी void. सो जो ऐसा एग्रीमेंट जो शुरू से ही void है, जिसको शुरू से ही पता है कि ये एग्रीमेंट इम्पॉसिबल है, सो ऐसे एग्रीमेंट शुरू से ही void होंगे। एलिमेंट और अब आपके सब्सिक्वेंट इम्पॉसिबिलिटीज हम लोग देख सकते हैं सेक्शन 56 की। What if the parties enter into the contract and at the time of entering it was possible to perform the contract, but due to some waning reason or factor beyond the control of either the parties, the performance of the contract become impossible or unlawful. Agreement of such nature are frustrated and hence void. For example, A agreed to sell a tract of land to B, but owning to some government policies, this tract of land has been taken by the government for some official purpose. So the agreement is then frustrated and B cannot sue A for non-performing of his obligation as the performance of A is duty is become impossible. So इस कॉन्ट्रैक्ट में क्या बोला गया है कि एक ने एक एग्रीमेंट किया बी को, कोई गवर्नमेंट की अपनी ये लैंड है मैं आपको सेल कर दूंगा, बट क्या हुआ, मीन वाले गवर्नमेंट ने वो लैंड एक्वायर कर ली और बिकॉज ऑफ द गवर्नमेंट पॉलिसीज इट्स इम्पॉसिबल फॉर ए टू complete that agreement and the contract, then A cannot be A cannot have any obligation as the performance of A duties become impossible. Okay, so that is it. And doctrine of frustration हम लोग समझ सकते हैं, there is a well known case law of Taylor versus Caldwell. Okay, this is very famous case, is a landmark case. The defendant agreed to allow the plaintiff to use their music hall to conduct a concert for a few days. Okay, so जो प्लेंटिफ है उसने अलाउ किया डिफेंडेंट को कि वो अपना उसका म्यूजिक हॉल जो होल है वो एक प्रोग्राम के लिए यूज करना चाहते हैं, म्यूजिक होल, to conduct a concert. Okay, but before the performance of the concert, the hall was destroyed by fire with the fault of either the party. The plaintiff sued for their loss. The court quashed their argument, stating that the performance of the contract has become physically impossible because the destruction of the subject matter, that is the music hall, in the case. So that is the like court held in this case कि आपका जो म्यूजिक हॉल था वो जल गया था, और because of that like the parties are not liable for the same, and now this contract is impossible to perform. So now and this contract would become void itself. Okay, because the contract is frustrated now. And there is a one more case law. There's a Carroll versus Henry. The principle is not restricted to the physical impossibility. It is also applied to case where the very reason object where the parties enter into the contract for to the materialize. The well-established authority is Carroll versus Henry. In the case, the defendant was keen to watching the coronation procession. So they hired a flag for the plaintiff for June 26 to June 27. But owning the king's illness, the procession was cancelled and the defendant refused to pay the money for the flag. So इस केस में क्या हुआ, कैरल वर्सेस हेनरी में प्लेंटिफ ने एक हॉल बुक किया, सॉरी डिफेंडेंट ने एक हॉल बुक किया कि राजा की जो एक यात्रा निकलेगी उस यात्रा को देखने के लिए, बट राजा बीमार पड़ गया और उसकी वजह से वो जो यात्रा थी वो कैंसिल हो गई. तो डिफेंडेंट ने जो है रिफ्यूज कर दिया मनी पे करने से फ्लैट के लिए, बिकॉज ही इज नॉट यूज द फ्लैट एट ऑल, and because the king was ill and the procession was cancelled. Due to that reason he is cancelled the like contract is frustrated itself. The court held that the doctrine of frustration apply as a very object of the contract is recognized of both the contracting parties was to have a view of the coronation process. The happening of the coronation hangs from the heart of the contract. The very object of the contract was frustrated by the non-happening of the coronation, and the plaintiff was held not entitled to receive money as rent fee. So this is the holding of the court in this case, Kera versus Henry. Now the doctrine of frustration is like there's a specific ground for the frustration. The doctrine of frustration is applicable of the grant variety of the contract. It is impossible to lay down the straightforward list in which this doctrine applies and in which the doctrine does not apply. The law in this matter is always growing and evolving, yet there are few well-established situations recognized by the courts where the doctrine of frustration apply, and they have been discussed below. So I am just going to let you know the situation where this doctrine of frustration is applied. Okay, like that, or incapability of the parties. So suppose there is two parties in a contract and one party is die. So because of that, like now the contract is frustrated, and now this contract is impossible to perform because one of the parties are die. Like suppose you hire a singer for sing a song in a concert and that singer is die. Now this contract is frustrated itself. This contract is void itself because now this contract is not impossible to perform because that person is no more in this world now. Government, legislation, and administrative intervention. And suppose it's happened like you have such contract with somebody and the government will interrupt in between, or there is a policy maker in the favor of the public, and so because of that contract is frustrated. So it's happened sometime. Non-occurrence of contemplated events, and something is happened which is not in control of the parties. Like suppose you book like the earlier example, like in the case of the Kerala, I think. So is in that case also we discussed, like suppose you book a hall and that hall is burned in a fire. So now you are not like it's not in the control of the parties. So basic element is there. So now the contract is frustrated itself because it's impossible to perform now. Change of the circumstances. Sometimes it's happened the circumstances will change, and because of these circumstances, it's impossible to perform that kind of contract. So in that situation, in that circumstances, that contract is frustrated itself and destruction of the subject matter. Okay, so this is false or five conditions where the specific ground for the frustration of the contract. So conclusion, we can conclude here. The doctrine of the frustration as provided under section 56 of the Indian Contract Act 1872 is an exception of the general rule of the contract where compensation is provided in case of loss. Hence, it can be understood that the contract gets frustrated when without the fault of either of the parties and performance of the contract become impossible, then this doctrine of frustration is arise. In conclusion, the doctrine of impossibility is to perform in a legal principle that provide relief to the parties when unforeseen event make it objectively impossible to fulfill contractual obligation. So this is all about it. So suppose if you like the video, like it, comment, share, subscribe the channel. Thank you for watching.